Ronald J. Pestritto is a senior fellow with the Kirby Center, Shipley Chair in the American Constitution, and associate professor of politics at Hillsdale College. Pestritto earned his BA in government magna cum laude at Claremont McKenna College and his MA in politics and PhD in political science at the Claremont Graduate University. His books include American Progressivism, A Reader, and Woodrow Wilson and the Roots of Modern Liberalism. Pestritto has also written for the Wall Street Journal and appears on the Fox News Channel. Beginning in 2012, Dr. Pestritto will be the Dean of Hillsdale College Graduate School of Statesmanship. Today, Dr. Pestritto will be speaking on the timely and pressing topic, the Obama administration versus the Constitution. Please join me in welcoming Dr. Pestritto.
Thank you, Catherine. It's nice to come to D.C. and see some of my students, present and former, here, and some friends, Ken and David. Good to see you guys. Thanks to everybody for coming out this afternoon. It's actually the second of these First Friday talks that I've given. I gave a talk at one of the very first principles on First Fridays. That was maybe a couple of years ago now. It doesn't seem like that long ago, but that was back when the Kirby Center was here in D.C., sort of embodied in the person of David Bobb, but wasn't actually here in this sort of marvelous new facility. So this is really the way to do it. It's a pleasure to be here. Of course, much has transpired since then, and that's sort of what my talk is about this afternoon, because indeed much has transpired that seems to make it particularly appropriate that we are here, that the college is here, and has this enterprise in D.C. Dedicated to the study of the Constitution and to the principles of the founding. After all, as I'm sure certainly everybody in this town has noticed, the American founding is very much back in vogue these days. In the debates here in D.C., and of course, I think throughout the nation. The debates we have about our major issues. In those debates, in addition to arguing about the pros and the cons, the policy arguments, if you will, we are also talking about whether the Constitution actually permits the government to make the policy in the first place. Right? That's kind of a novelty, at least in recent memory. And really, I should say that it's almost as much of a novelty for conservatives as it has been for liberals. Those of you here who may be from the House side of the Hill even took the trouble to undertake a public reading of the Constitution at the outset of this new Congress in January. And I think it was an important signal that Congress at least intends to abide by the charter that, as we know, is of course the only legitimate source of its power. Now, among national elites, many appeared not to be all that impressed by this reading of the Constitution, although really my guess is with wide swaths of Obamacare now having been declared unconstitutional by various federal courts, really they may be taking constitutional questions, I think, a little more seriously than they'd like to let on. But nonetheless, the New York Times called the House's reading of the Constitution, quote, an empty gesture, and Representative Jerry Nadler called it, quote, total nonsense. Now, lest we are tempted to think in overly partisan terms, this disregard for the Constitution has not, I think we know, been the sole province of the left. When, for instance, President Bush signed the McCain-Feingold campaign finance restrictions into law, he proclaimed that, well, he thought they were probably unconstitutional, but he was going to sign them anyways and let the courts figure it out. This from somebody, again, who swears to preserve, protect, and defend the Constitution of the United States. So the point of that is to say that it's a good thing, I think, that we are starting to take the Constitution more seriously in our national political debates. However, having said something about Congress, the greatest threat to constitutional government right now, I think, isn't really taking place within the debates in Congress. As we've started to see already, I think the real action over the next couple of years will be in the bureaucracy, as much, if not more, than it will be in Congress. Congress, of course, makes laws, but over the last century or so, these laws have been written in such a way, and they have been written so vaguely, that the real policy making is done by the bureaucrats in the agencies that have been created to implement and to administer the details of our laws. The examples of this scenario, of this way of doing things, are abundant, and we don't need to look to ancient history for them. Indeed, as many of you are no doubt aware, certain elements of the current Congress itself are now on the case, as the recent attempts, for instance, to rein in the EPA, I think, have demonstrated. The EPA, of course, is presently in the process of issuing final rules regulating greenhouse gas emissions. Now, due mostly to concerns over the impact of these rules on the economy, you may recall that a similar scheme of regulation garnered strong bipartisan opposition in the last Congress and failed to pass. This was the big environmental initiative that did not make it through. Cap and trade, I guess, is what they were calling it. And you may, in fact, remember that then Senate candidate Joe Manchin won election from West Virginia due in part to a commercial which showed him shooting a high-powered rifle through the cap and trade legislation. Right? That's how unpopular this was. However, in spite of this legislative failure, right, that is to say, in spite of being rejected, voted down by our elected representatives, these rules are right now in the process of becoming law. Now, such a maneuver is possible, of course, because when Congress enacted the Clean Air Act and enacted its subsequent amendments, it defined the EPA's power in such broad terms and in such vague terms that it amounted to essentially to a delegation to the agency of the very legislative power that the Constitution reserves only for Congress. A lot of people blame the courts here, and certainly they share their part of the blame, but it also has a lot to do with the way Congress wrote the law in the first place. In a similar example, we know that Congress in 2008 considered and voted against a taxpayer-funded bailout of major American automobile manufacturers. Nonetheless, the Treasury Department proceeded to bail out both General Motors and Chrysler, almost immediately after Congress voted it down. Treasury is able to do this, of course, because the previously enacted TARP bill, Troubled Asset Relief Program law, supposedly passed for the purpose of bailing out banks and other financial service entities, had been written vaguely enough that the Treasury Department had ample discretion to divert funds to a wide array of entities having little or nothing to do with the financial services industry. And if you go ahead and look at that TARP law, you will see that they had enough room to drive a truck through. The same kind of lawmaking by unelected bureaucrats is, of course, a central piece of Obamacare. You may remember how the former Speaker of the House responded to those who were complaining that they hadn't had a chance to actually read the health care legislation before they were asked to vote on it. Right? And she said that, well, we first had to pass the legislation so that we could then learn what was in it. Right? Now, of course, you may have laughed, you may have rolled your eyes, you may have, put your foot through the television or something like that. However, I hope you can see, sort of take from what I'm saying here, that really that was a perfectly truthful answer, if extremely disturbing. It was a perfectly truthful answer. The Obamacare legislation itself, right, as long as it is, a couple thousand pages, I guess, if I recall correctly, actually makes very little specific policy. The real decisions are delegated to the bureaucracy. We've seen this in the months since the passage of the legislation. In less than a year since Obamacare has passed, in fact, the Department of Health and Human Services, to whom most of this discretion is delegated, has issued a variety of rules. Some of these rules go as far as imposing a ceiling on insurance industry profits and de facto price controls on private insurance premiums. Right? A whole host of very far-reaching policies that really have been left up to the discretion of the unelected folks down at the Department of Health and Human Services. And of course, while Obamacare gets all of the attention, those of you who are involved in financial regulation know that the Dodd-Frank financial regulation bill may in fact be even more sweeping in just the sort of blank check authority that it gives to unelected bureaucrats to make rules which are to have the force of law. Dodd-Frank is basically a tabula rasa that the Wall Street Journal calculates will require no fewer than 243 new rules by 11 different agencies over the next decade or so. And I'm talking major rules. Talk about a bill that first had to be passed before we could find out what was in it. We're going to be finding out what's actually in Dodd-Frank over the next 10 and 15 years. Well, there are a lot of these examples, as many of you know. I could go on all day. I won't. Just one more. You may recall the union card check legislation that was a big priority for the left in the last Congress. Right, this was to get rid of the secret ballot in union elections so that the union officials could tell who was voting against organization, and I'm sure gently persuade them, engage in reasoned dialogue with these dissenters. But you may also recall, of course, that this legislation failed to pass the last Congress. Right? Again, our elected representatives did not enact it. However, our unelected friends over at the National Labor Relations Board have been very busy these days. As we speak, they are busily hauling state governments into court in order to overturn anti-card check legislation that has been enacted by voters at the state level, and now in order to attempt to undo the right-to-work laws that exist in a lot of the states. If you've seen the Boeing case and what's going on in South Carolina, right? Well, one final thing: our friends over at TSA, by whom I was groped just yesterday on my way here. Especially since Washington has taken the form of an armed camp this week, I've noticed. It's amazing. They're doing their part to thwart the will of our elected national legislature. When Congress created the TSA in response to 9/11, it put a provision in the law that allowed TSA functions to be carried out by private companies. And it's, in fact, a little-known fact that a few airports around the country chose this option and have been operating this way for years. However, when interest in this private option peaked over the recent complaints about the TSA, the unelected TSA administrator issued a statement saying that his agency would refuse, as a matter of policy, to approve any more private opt-out applications from airports. Right? As a matter of rule, they wouldn't even look at the specifics any longer. So the point of all of these examples is simply to have you think about the following question: who is really governing here? Who's making policy? Is it our representatives in Congress who have to answer to us, answer to their constituents through elections? Or is it bureaucratic administrators who aren't elected and who, most of whom have guaranteed life tenure, regardless of whether or not you approve of the policies they make every day? Now, I'm not going to shed a tear for Congress in all of this as some kind of innocent victim here. Right? We know that the only reason that bureaucrats exercise what amounts to lawmaking power in this country is precisely because Congress has given it to them. Congress can take it away anytime it wishes. Right? And the reason it hasn't done so at least until attempts at these few recent exceptions, is very simple. Right? Under the current arrangement that we have, that I've just been giving you examples of, members of Congress are able to take credit. They take credit for enacting vague, kind of nice-sounding platitudes into law. So we enact things like, we mandate that there's going to be clean air, or we enact a mandate that universal, affordable health care for everybody, right? As if, right, that can be done at the wave of a wand or the snap of one's fingers, right? Who's against those things, after all? And then, of course, when it comes down to actually making the tough policies, the actual laws that cost people their jobs, that cost our economy its productivity, where you have costs and benefits to weigh and real winners and losers who have to be identified because the power of the government's going to be put to use, well, then congressmen have been perfectly happy to let members of the bureaucracy make these difficult choices for them. Right? Someone else, therefore, is to blame. And then, of course, as everybody in this town knows, then they really pour it on, right? They have oversight hearings, and they haul the hapless bureaucrat up before the congressional committee and berate said hapless bureaucrat for doing all of these awful things and enacting all these awful policies, which, of course, Congress itself has empowered the bureaucrats to make in the first place. And it's a big game, and it's a big theater. Again, hard not to laugh at that, and of course it would be funny if it were about some other country. As I've spoken to groups of concerned citizens over the last couple of years, to me it's become very evident that this situation has people profoundly concerned, and many of these people have not been politically active until recently. And when, the last couple of years have really been a kind of revelation to a lot of them. What has people most concerned, I believe, as demonstrated by some of these examples that I've been talking about, is the fear that they have that they may be losing the ability to change things through election. Right? That elections no longer matter, that with the administrative state that we have, with Congress passing laws in a way that hardly makes it accountable for their consequences, we're really losing our grip on representative government in this country. Now add to that a related problem, which I think also rises from the growth of the administrative state, and it's a phenomenon, again, I think I can best illustrate by way of example. Earlier this spring, we learned of many companies, many organizations being granted waivers from certain requirements of Obamacare. It really was quite remarkable just how many of these were being handed out. Last I recall, the Department of Health and Human Services had granted over 1,000 of these, although there may well be folks in this audience who have more updated figures than that and who know more about it than I do. But that was just the last time I looked. And of course, given the massive burdens and the massive costs of Obamacare, it certainly shouldn't be surprising that people want to be exempted. Sure wish I could be exempted. What is a little shocking is that the folks being granted waivers from the law are in many cases the very same folks who lobbied so hard for the law's passage. Just a random example. Our friends at the Service Employees International Union, SEIU, get the award for a particularly high degree of shamelessness, as they lobbied hard against the repeal of Obamacare in the Senate earlier this year at the very same time that different organizations within the SEIU were receiving waivers because they didn't want to be subject to Obamacare's onerous regulations. At the same time. Again, you might be asking yourself, how do I get one of these waivers? This would be great. If they're handing out so many, where is the line? Well, certainly being in the favor of the Obama administration bureaucrats who administer the law would be a good first step. Hillsdale College will not be getting any of these waivers anytime soon. I'm quite confident of that. The point is this the rule of law? where everybody is treated equally under the law? Or is it the rule by favor of the crown, where those in good standing receive special treatment? Another example of this problem. I've already mentioned the bailout of General Motors. Some of you may also recall that this bailout was undertaken on the basis of what I think has to be the most egregious violation of the rule of law I've seen in my lifetime. Turns out, of course, GM had borrowed a lot of money. It was having a little trouble paying back. A good chunk of that money was owed to secured bondholders. Many of these were pension funds who were making investments on behalf of retired teachers, police officers, just average people. And these people loaned their money because under the clear terms of the law, they would be first in line to be repaid in the event of a bankruptcy. That is the law of the land. Problem was, if that law was followed in GM's case, it would mean that these secure bondholders would be paid and that the generous contracts held by the United Auto Workers Union, which by clear law come last in line, they would be in jeopardy. Well, the Obama Treasury Department wasn't about to let that happen. And so through various strong-arm tactics, through name-calling against these, high-rolling financiers, that is to say, representing the average people in their pension funds, through these kinds of tactics, the law was simply set aside. Right? And it was set aside to favor these friends of the government. And it was done at the expense of those who didn't have such powerful friends. Now, these are not further attempts on my part to depress or enrage you, as the case may be, but rather I point to them by way of contrast to make a point about the virtues of our constitutional system. Our Constitution and the system of the rule of law that it established has until recently been the envy of the world. And if we reflect on the principles of our founding, we can see the wisdom of our constitutional framework. Our founders understood that there are essentially two ways in which government can exercise its authority. The first of these is a system of arbitrary rule. That's one where the government decides how to act on an ad hoc basis, granting decision-making power to the whim of whatever official or officials happen to be in charge, relying on the expert judgment of these officials. They know best, they've got the education, they've got the training, they have the prudence, and so on. The second way for government to exercise its authority is to implement a system grounded in the rule of law. And it is a wonder that in this day and age one actually has to go back and define, and I find this all the time for my students, I have to define what the rule of law means, because it's been so taken for granted in this country that we're on the brink of losing it. In this system of the rule of law, legal rules are made in advance. They're published. They bind both government and citizens. And they allow the citizens to know exactly what they have to do or not do, as the case may be, in order to avoid the coercive authority of the government. So the founders implemented this rule of law system. They did it partly out of reaction to the schemes favored by the likes of Massachusetts Governor John Winthrop in the early years of Puritanism in the United States. Winthrop believed, of course, that government policy ought to depend upon the wisdom of the government official. Right? And under a system like this, where the wisdom of the magistrate is to govern, no one knows for sure what the rules are. No one knows what the penalties are for violating the rules. Nothing except the goodwill of the magistrate keeps the government from acting according to whimsy or dictatorial willfulness. And so against this scenario, I think the advantages of the founders' rule of law system are perfectly evident. First thing is that the rule of law facilitates government by the consent of the governed. Right? Rules are made in advance. They apply to a broad array of cases that may arise in the future. And thus the people have the opportunity to consent by way of deliberation and by way of the votes of their elected representatives. Right? In a situation where ad hoc decision-making is used, A decision is made only once a particular case arises. Provides no opportunity for the citizens to deliberate and to consent. A second advantage of this system, apropos of the cases I've been referring to, is that it makes it much more difficult for government to play favorites, to benefit its personal friends, right, to harm its personal enemies. You may have noticed the news recently that the Obama administration intends to issue an executive order where it will want to know about the political donations of those who are being considered for federal contracts, just for record keeping, mind you. That's why the rule of law system is the best means of maintaining a government dedicated to the equal protection of its citizens' rights, which is, of course, the aim and the goal of all legitimate government, as the American Declaration of Independence tells us. So in order to secure individual rights in a system that is based upon the rule of law, we know that the founders instituted a constitution designed around a separation of powers model. Under this model, the legitimate authority of the government is exercised by three co-equal departments of government, each making sure that the others remain in their proper place. The fundamental aim here is to safeguard rights against the possibility of arbitrary government. In fact, James Madison, in Federalist number 47, redefines the word tyranny to mean the absence in government of the separation of powers. When you don't have separation of powers, you've got tyranny. And of course, when he made that point, he was simply quoting from Jefferson in Jefferson's Notes in the State of Virginia. Now, it's from this fundamental aim of separation of powers, this aim to protect individual liberty, that we can discern, I think, three important tenets, three important principles of the American Constitution that bear directly on the situation with the administrative state today. This is by no means an exhaustive list, but I think it gets to the heart of the problem. The first would be the principle of what's called non-delegation. In other words, if the separation of powers means anything at all, it means that one branch of government may not permit its powers to be exercised substantially by another branch. Pretty straightforward. If you have that, you don't have separation of powers, right? Second principle, corollary of the first, no combination of powers within a single branch. All right? Here, again, Madison, quoting Jefferson in the Federalist Papers, says the following: the accumulation of all powers, legislative, executive, and judiciary, in the same hands, may justly be pronounced the very definition of tyranny. So under this second principle of separation of powers, tenet vital to maintaining the rule of law, those making the law must also be subject to that law being enforced upon them in the same way as everybody else by an independent authority. Those involved in the execution of the law don't get to write it first before they enforce it. They don't get to make it up as they go along. Right? Instead, they have to enforce laws that have been previously established by a separate authority. In other words, when HHS goes about enforcing Obamacare, it shouldn't get to write the rules first before it enforces them. And finally, under this principle of separation of powers, those on whom the law is enforced have their cases judged by an authority entirely separate from the hands that bring the prosecution. Right? And this is elemental American civics. Third tenet of the separation of powers, responsibility of administration to a popularly elected executive. Right? The government remains wholly popular, to use the phrase of Federalist number 14, because those who carry out the law, the administrators, as we call them today, the bureaucrats, they are directly answerable to the president, who's elected. Remember, the Constitution grants all of the executive power in Article 2 to the president, and it requires that the president take care that the laws be faithfully executed. So administration, as powerful as even some of our founders surely envisioned it, but administration was placed wholly within a single branch of government. Clear line of political accountability for administrators is established that way, so that when they exercise power, it takes place only within the confines of law, only within the confines of popular consent. Now, for those of us who think that these principles make a certain amount of sense, who are concerned with really restoring the Constitution to its full authority in our government, need to look very carefully at how the administrative state functions today. And the best way to think about it, it seems to me, is to contrast these principles I've just outlined with some basic facts about the way that bureaucracies exercise power. First, there is the basic and unavoidable fact that the administrative state today is built on governance by expertise at the expense of governance by consent. And nowhere is this more evident than in the abandonment of what I have called non-delegation, which abandonment is the pillar of the administrative state today, the thing without which it could not exist. As I've tried to show in these examples, it has become standard practice for Congress to pass extremely broad and vague political goals, to call that law, and to delegate to administrative agencies, that is to say to the executive branch, the responsibility of coming up with the actual law, with the specific policies required to achieve these broad goals. A great historical example here is the law enacted by Congress back in the 1930s to establish and empower the Securities and Exchange Commission. In laying out what is supposed to be a specific policy for the SEC to enforce, this is what Congress says in the law. Quote, "The Commission shall make regulations that are in the public interest." End quote. To cite an even better example, in the legislation on broadcast licenses, consider how specific Congress was in writing the law that empowers the Federal Communications Commission. It directs the FCC to, quote, "grant licenses if public convenience, interest, or necessity shall be served thereby," end quote. Right? Who determines what exactly is convenient, what exactly is in the public's interest? Is it Congress who actually has to be accountable to voters for representing that interest? Or is it the bureaucracy, which has no accountability to the people whose interest it is asked to represent in these laws? Second major inconsistency is the undermining of separation of powers by the combination of powers within single agencies. And here it's a slightly more complicated scenario than I have the time to describe, because there are different kinds of agencies in the federal government. Some are more independent than others. Okay, so with that caveat. But here there's a legal scholar who has done excellent work on this, a fellow by the name of Gary Lawson. And he's especially looked at the independent agencies that make a lot of policy in our national government. And I have a favorite quote from him that I like to read, and I'll indulge myself again, because it's a very accurate account of how the Federal Trade Commission works today. In fact, I'm here with my son, getting in a little sort of educational tour of Washington while I'm here for the lecture, and we walked by the FTC today, and I'm going up and down Constitution Avenue explaining which agencies are constitutional and which ones aren't. So we went by the FTC, and I had to put the quote in my speech. But this is Lawson, apropos of the idea that you can't combine functions in a single set of hands. This goes to the very bedrock of our constitutional principle. This is Lawson's account. He's a lawyer. He knows what he's talking about, of how the FTC operates. Quote, "The Federal Trade Commission promulgates substantive rules of conduct." It means it makes laws. The Commission then considers whether to authorize investigations into whether Commission's rules have been violated. If the Commission authorizes an investigation, the investigation is conducted by the Commission, which reports its findings to the Commission. If the Commission thinks that the Commission's findings warrant an enforcement action, the Commission issues a complaint. The Commission's complaint that a Commission's rule has been violated is then prosecuted by the Commission, adjudicated by the Commission. Okay. Now, the Commission adjudication can either take place before the full Commission or before a semi-autonomous administrative law judge. If the Commission chooses to adjudicate before an administrative law judge rather than before the Commission, and the decision is adverse to the Commission can appeal to the Commission. All right. That is exactly how the FTC operates. It's exactly how a lot of our independent agencies operate when they make policy. It's not an exaggerated account of the agency's decision-making process. Finally, as a third major inconsistency, I would point to the weakening in today's administrative state of the political accountability of administrators and the shielding of large subsets of agencies from real political control. Now, as I've said, given the complicated structure of the executive branch, some agencies are more independent than others, of course, even with the existence of the civil service system. It is nonetheless a fact that federal courts have recognized the power of Congress to create agencies, presumably they're part of the executive branch, where else constitutionally could they be, after all, but that are nonetheless shielded from direct presidential control. Kind of scratch your head. How are you in the executive branch if you're not controlled by the president who's given all the executive power? Not quite sure how that works. Check out some Supreme Court decisions back from the 1930s if you're interested in the kind of tortured logic. Normally, the shielding is accomplished by limiting the president's freedom to remove agency personnel. Now, these rulings reflect the acceptance of a key tenet of progressive administrative theory. Right? That is to say that many areas of administration are based on expertise, they're based on neutral principles, they must therefore be freed from the influence of politics and electoral accountability. So these are all inconsistencies, one might even say fundamental differences between the founders' constitutionalism and the principles of our administrative state today. Right? Now, if I were here to give you a different talk, or if I were giving the talk I think that I gave a couple of years ago when I was here, I would launch into an historical explanation of how the move from the principles of the founding to the modern administrative state occurred. But that, I think, certainly would be overstaying my welcome here. But the very short version of that is that the progressive movement, which of course came to its height at the turn of the 20th century in America, really became impatient with the limits that were imposed on the federal government by the Constitution. Right? You want to see the personification of that impatience, see Teddy Roosevelt. In order to handle the vast array of the new redistributive and regulatory powers that the progressives had in mind for the national government, it was necessary to erode these constitutional limits, and it was also necessary to come up with an administrative system that was capable of managing the whole new set of responsibilities, the whole new set of federal programs and endeavors that the progressives had in mind. So it shouldn't surprise us that those calling themselves progressives today remain strongly attached to the kind of discretionary expert governance that was launched by their ancestors in the original progressive movement. But as I said, that's really a story for another day, or a story that I've already told. Let me finish with this, because I think it's important if we are to reflect on our responsibilities as citizens within a constitutional republic. I said a few moments ago that separation of powers was key for the founders, because among other things, those making the law wouldn't be the same as those enforcing it. The point of this, of course, is to make sure that those making the laws will do so with the knowledge, again, that they themselves will also be subject to that law and will have it enforced on them equally by an impartial authority. All right? That is a bedrock protection of the people's liberties. So reflect on that for a moment, and then reflect on the following fact. Because members of Congress have their health care paid for by the American taxpayer, they in fact will be shielded from the worst effects of the so-called health care exchanges into which all of us are going to be thrown. Now, while it's not quite right to say that Congress is exempted from Obamacare, that's not the case. Although maybe if it's nice to HHS, it can get a waiver. But it is the case that it will not feel its burdens in the way that most of the rest of us will. Reflect, too, on the waivers being granted from this law to those who hold the favor of the government. And reflect finally on this passage written by James Madison in the 57th Federalist paper. This is what Madison wrote, quote, "If it be asked what is to restrain the House of Representatives from making legal discriminations in favor of themselves and a particular class of society, I answer, the genius of the whole system, the nature of just and constitutional laws, and above all, the vigilant and manly spirit which actuates the people of America, a spirit which nourishes freedom and in return is nourished by it. If this spirit shall ever be so far debased as to tolerate a law not obligatory on the legislature as well as on the people, then the people will be prepared to tolerate anything but liberty. So are we in America ready to display what Madison called our manly and vigilant spirit, which he said nourishes freedom? Or are we instead prepared to tolerate anything but liberty? I think we're in the process of answering that question in American politics right now. I think the next few years in American politics will go a long way to answering that question. So let me conclude with that. Thank you for your patience, your endurance, and I would be happy to take any questions that you might have. I'm told I'm running my own Q&A period here. So, who's up? Yes, ma'am.
Hi, my name is Linda, and I am the Republican woman of Clifton. And we talk a lot about the lack of constitutionality and a lot of the things that President Obama is doing. Where do you see the fight beginning, if it can be done, in the branches of government? Where do we begin the fight? Which one do we take over first in order to really turn things around and go back to a constitutional system? Because I feel like this is a head with 10,000 snakes, and you don't know where to start in order to...
Yeah, well, I mean, I think that the first essential step was taken in 2010 in the midterm elections. And by that, I mean, the solution is a political solution. It has to be. That's what Madison means in that passage. If the people themselves can't elect representatives who are going to protect their liberties, if they can't be vigilant about that, then we're lost. And there's a tendency, and I mean, I highly sympathize with it. Maybe the Supreme Court or maybe the courts will come in and they'll march in and they'll save us. They'll take the Constitution and use it like a hammer on these guys who've enacted all of these laws that we think are unconstitutional. Obamacare, the obvious one. Everyone's, gosh, maybe we can get 5 votes and we won't have to. There may be some victories that come that way, short term. I mean, it may be, you get enough judges together or something. But in the end, I mean, it seems to me that the judiciary is going to go as politics go. I mean, that's always the case. And furthermore, Congress really is in control of this. The administrative state is created by Congress. It is nourished by. It's funded by Congress. Its authority comes from Congress, and so I think the way to start is it's encouraging to see some of the attempts to take back authority from agencies like EPA. I think there's going to be some run on NLRB, my guess is, and these arguments are starting to resonate. You see floor speeches, where the Constitution is referenced. These arguments about delegation. These arguments have not been raised. I don't know when the last time they were raised. And in fact, many on the right have made their peace with some constitutional, sort of blind eye toward this kind of delegation. So that's where it has to start. There's a lot of, it seems to me, measures percolating in Congress which are going in this direction. Obviously, more is needed. Those aren't probably going to go anywhere if you don't have a president who's willing to sign them. I mean, that's an obvious fact. But that's where you start. Congress created this. Congress has the power, with a stroke of a pen, literally with a stroke of a pen, to undo it, or, I mean, let's be realistic, to start, peeling back a little bit, right? So that's where you start, right? So you do what you did in 2010. Get out there, get good candidates, get them elected. Keep the pressure on those who are elected, not to get comfortable with the situation that's been created. Let people know that they're being watched. That's. I just read. Was it? Where was it? It was somewhere this morning. I read that Senator Snowe she filibustered her own small business bill because they weren't going to allow a vote on. I'm probably botching this. I'm sure there's someone from the Senate here, but they weren't going to allow a vote on this amendment, which is going to rein in some of the authority of some agency. I think the EPA. So even why? Because she's got a challenger. Probably she's going to get. So that's how this is done. Right. Yes, ma'am.
The ability of the president to write executive orders.
Yeah, the question was, I take it, is there a kind of tension between executive orders and if you're to sort of restore non-delegation? Yes, and the president is given a lot of responsibility constitutionally, and he's given, and Congress constitutionally grants the executive power to, and the Constitution says, Article 2, he has to take care that the laws be faithfully executed. In other words, in order for the president to carry out his constitutional responsibilities, he has to issue orders, he has to have people that work for them, he has to tell them what to do, he has to establish policies within the executive branch. So I'm not arguing, by any means that the president, can't or shouldn't be able to make orders governing his own branch within the confines that the Constitution gives to his branch. So that is, the question is not so much the executive orders, right, but their scope. So do the executive orders take the place of law? Are they executing law, or are they making law? And that's the difference. And when the courts have considered this delegation question, what they look at is, what does it mean to make a law? How specific does Congress have to get in setting the policy, right? When does it become Congress is so vague that it's just hey, you figure it out? And that's where the argument, and it seems to me that's where you have to deliberate about the line being drawn. And this isn't about, by the way, getting a puny or kind of impotent executive. Not at all. We know that many of our founders, energy in the executive is a leading character in the definition of good government. That's Hamilton from Federalist 70. We needed a vigorous administration. It was one of the problems of the Articles of Confederation. So let's not sort of think that the idea here is to have a kind of minimalist sort of system. As appealing as that sounds, given some of the policies these days, but rather it's to have a powerful government when it needs to be powerful within constitutional limits. I mean that's an important distinction. You want to follow up? Yeah. Well, Congress has the power to make law, and to the extent that the executive orders purport to make law, presumably Congress would have something to say about this. Part of this is part of the healthy tension, of course, that exists between the legislative and executive branch. The problem is when the legislative branch has an interest in giving its power away, right? Because that's a frequent question I get. Well, that seems kind of contrary to human nature that you give away power. Well, because it's part of the game of being able to maintain your pay, power, and prestige. You give away the blame, you take the credit. I mean, that's how that works. So the incentives are slightly, sort of messed up in the way things are done right now. Okay. I'm going to go over here, then I'll come back over here. Yes.
Dr. Pestritto, I have an online question. Chelsea from Dallas, Texas asks, I've heard a lot of people complain about the president's use of czars. I'm not convinced that they're that bad. Since they're directly controlled by the president, do you feel that they might actually be more useful and more constitutional than regulatory agencies?
Yeah, well, that's a perceptive question. I usually get in trouble in front of conservative audiences because I think, to a certain extent, I think the czar system is as much ado about nothing. I mean, that is to say, if it's the case, right? If you know, what's the best argument to be made constitutionally for czars? Okay, you have parts of the administrative state. Let's take transportation policy, for example, just to pick one randomly. And you could have 10 different agencies that are involved in implementing transportation policy, okay? Is it really constitutionally problematic for the president to have somebody who answers to him, who's close to him, who's in his White House office, and to say, you know, you're going to be in charge of coordinating and overseeing the various agencies as they implement transportation policy, because I want to make sure that transportation policy in this administration is carried out in accord with my wishes, because, by the way, I'm the only one who gets voted for around here, right? I'm the elected representative. And so partly the czar system, and this is not novel to President Obama. This goes way back. I mean, President Nixon was one of the first to try to reach out and control more of the administrative state in a manner that was closer to him, more politically accountable to him. That's one of the reasons why he was absolutely hated. You know, there's a lot of reasons why, but I mean, that certainly is one. A lot of people don't understand that. So in that respect, there actually is a constitutional argument to be made on behalf of czars. Now, the problems come with the fact that they exist without Senate confirmation and all of that. There are a host of constitutional issues that do arise. I agree with that, but it seems to me that that's kind of the czar system is kind of a red herring. The fact is, why does the administration have this power delegated to begin with? I mean, it's really the delegation issue, I think, more than the czar issue. I think I promised to go over here.
Hi, my name is Amanda Broadnax, and I currently intern on the Hill. And I noticed that with the recent elections, a lot of people got voted into office on the promise that they were going to make sure that new laws cited the constitutional authority to them. I haven't really seen that occur, and I just want to know, what is your take? Do you think that that's just for show, or can this be something really useful to kind of hold some of these elected officials accountable and make sure that we are creating laws that are compliant with the Constitution?
Yeah, I think, now certainly, of course, it seems to be entirely appropriate that legislators who take an oath, to uphold the Constitution should reflect and should have to reflect in a very direct and specific way on where they draw the authority to enact the policy that they are purporting to enact. So that seems to me to be perfectly sound. The problem is, of course, that people can be very clever about taking the words of the Constitution and twisting their plain meaning, or they can take advantage of clauses in the Constitution that don't seem to be quite so specific. So problem is, in practice, if you don't have legislators who take to this task honestly and forthrightly, what it becomes simply is, well, it's kind of paperwork requirement. So let's get the box. Well, interstate commerce. Let's check that one, or let's check the general welfare. That's always useful. Let's check that one. And so it becomes a kind of as a practical matter, it becomes a kind of sort of, as you say, for show. Part of the problem here is, of course, that. Again, to reflect on the words of Madison, the people themselves have to maintain a vigilance over how their government actually interprets the Constitution. And this applies not just to legislators, but even to the courts, right? The courts have been a partner, certainly with the growth of progressivism in the 20th century, to basically take the plain meaning of the Constitution, in certain cases turn it on its head. So that's why, as a practical matter, these sort of mandates to cite constitutional authority, which I'm all in favor of, in fact, kind of falter if legislators aren't held accountable, right? If people aren't vigilant about their liberty. I mean, and that's the, I think it's important to make the following point. There's a temptation we have, and it's an entirely, I think, reasonable one, an understandable one. There's a temptation we have to look at the Constitution as a kind of fix-all, as a kind of, cudgel. If we could just take that Constitution and hammer people with it, that's what we need to do. But what Madison is really saying in that document is, what matters more are the people themselves. Okay, so if you have a Constitution, it could have the clearest protection for liberty. It could be the best Constitution written, but the Constitution puts in place a series of arrangements which the Federalist Papers refer to as auxiliary precautions. They say they're kind of a backup plan. What's the primary precaution? It's the vigilance of the people, right? If you have a people who are corrupt, if you have a people who are completely dependent, who are slavish to an administrative state, who want to be taken care of instead of wanting to take care of themselves. If you have that, no Constitution, a Constitution handed down from God directly, would not save such a people. And so that's, to go back to my answer to the previous question, it really is the people themselves who have to be vigilant about this, or we're done for. I'm told I can take one more question. So where am I taking it from? Okay. Yes, ma'am. I just do as I'm told. So.
Allison Miller.
Speaking of a slavish attitude.
Yes, thank you for your talk. Allison Miller from the Heritage Foundation. I realize there's a lot of culpability to be spread around with the expansion of the administrative state, but could you pinpoint, I guess, the Congress, perhaps, or the moment in history? I mean, was it during the Wilson administration when the administrative state really, maybe the floodgates didn't open, but the trickle started,
Okay, so she's given me entree with that question to give my earlier lecture about the progressives. So about an hour, if you have about an hour, we'll go. Let me give the 1-minute version to the extent that I'm able. The modern administrative state is certainly built on the New Deal, because once you have, the policies that you get, coming out of the New Deal, you need an administrative apparatus to implement them. And in fact, I've done some studying of the design of the agencies. How is the SEC created? How are these alphabet soup agencies created in the New Deal? And there's turns out a lot of progressive influence. So those like, for example, James Landis, who was Franklin Roosevelt's kind of right-hand man, the architect of the design of these administrative agencies, and a huge advocate of the discretionary power to be given to them. He was a committed progressive, and he had sort of come of age in the progressive era, had learned from progressives, and so the progressives are kind of the intellectual. If you're looking for intellectual culprits, I'd say, the progressives. But really, it's those who were influenced by progressives in the New Deal. Especially, this became a problem for FDR himself, because you may have heard of something called the Brownlow Commission, which looked at how agencies work. And the Brownlow Commission was an attempt by Roosevelt to reclaim some of the power that, under the advice of progressives, he'd given away to the administrative agencies, because he was all for this expert governance until he realized, well, wait a minute, this means I don't have to do what I say. And so, there was some tension even within the Roosevelt administration over this problem. But that's you would look for the kind of architects. James Landis is I really get really excited about reading his book, The Administrative Process. This is how I spend my time. That's something I would recommend. If you're crazy enough to look into this. And then the sort of intellectual arguments are there in the progressives themselves. So that's a quick answer, or as quick as you're going to get anyways. Thank you very much. You've been a great audience. Appreciate it.